Hi there, Aiden Durham here, business and branding attorney with 180 Law Co. in Colorado. Welcome back to another exciting episode of All Up in Yo Business. Strap in because we're going through your comments, responding to them, and answering your legal questions. If this is your first time on my channel, welcome. Thank you for being here. Don't forget to subscribe and click that little bell button so you get notified anytime I post a new episode. You can also check the description for links to additional information and resources like my ultimate new business checklist that you can download for free. All right, there we have it. With no further ado, let's get this party started with a trademark question. If I apply for one goods and services, let's say coffee or tea, class 30, for a trademark, does that mean I have the right to everything under class 30, for example, baked goods, pizza, pasta? So for those of you who may not already be aware, when we apply to register a trademark with the USPTO, we have to indicate on the application the goods and or services that we're going to be using the trademark in connection with. And those goods and services are broken up into 45 different classes. We call them international classes. And within each class is a plethora of different goods or services descriptions that fit within that class. So what this question is asking is if in class 30 that applies to things like coffee and tea, if we apply for coffee and tea in class 30, does that also cover the trademark with respect to anything else in that class, such as baked goods, pizza, anything else that's in class 30? And of course, if you guys can't guess already, the answer is it depends. Generally speaking, our trademark registrations will cover the goods and services that we identify on the application, as well as any natural zone of expansion with respect to those goods and services. So what might consumers expect that we may also sell if we're selling these kind of products? And are there other businesses or companies out there that sell this product and this product? Are there a lot of stores or cafes where you can buy coffee and tea and pizza, baked goods, pasta, that kind of thing? So it depends on that to begin with. I mean, certainly I would say probably baked goods are within the natural zone of expansion with coffee and tea. It's pretty common to go to a place where you see coffee and tea being sold and they will also sell baked goods. But that in itself doesn't mean that you now own your trademark in everything in class 30. It just doesn't work that way. It also depends on the strength or weakness, the distinctiveness of your trademark. So if your trademark is very strong and very distinctive, then it will have a broader reach of protection outside of just the goods and services that you state on the application. But if your mark is on the weaker side, or if it's commercially weak, if there are a lot of other trademarks in class 30 that are kind of similar to your trademark, if it's on the weaker end, then that's going to give a narrower protection. So it depends. It's not a yes or no answer. I hate New York City. Can I form one outside of New York City? I ain't paying $2,000 in state fees. So this person is asking about forming an LLC or a corporation in New York State. I'm sure there are business registration requirements in New York City, but forming an actual LLC or a corporation would be done in New York State. Yeah, you can form a company in whatever state you want to. There are no restrictions that you have to live in this state to form a company in this state. But if you are living in a state operating a business in that state, then that state will want the company to be registered. So let's say you form, in Colorado, the filing fee is only $50 to form an LLC. So you can save some money by forming the LLC in Colorado, but you're still operating the business in New York. So your Colorado LLC is conducting business in the state of New York. And so the state of New York is still going to want you to register the LLC as a foreign entity there. So yeah, you can, but you're not really getting out of having to pay anything to the state of New York or New York City. Hello, I'm an author just starting out and I have a logo and brand name so I can tie everything together. Do you have any advice on whether I should copyright or trademark? So with a brand name and a logo, anything that is used to identify your brand, we're talking about trademarks. That's a trademark thing. If you want to protect your brand, then you can register the name and or logo as a trademark. Sometimes logos have enough creative element to it that they could also be protected by copyright. But a copyright gives completely different protection than a trademark does. And registering the copyright for your logo won't protect it as your brand in the same way that a trademark will. I've done a video in the past kind of explaining more how a logo plays in the trademark copyright realm kind of at the same time. I will put a card for that and link to it in the description if you want to learn more. If you create a business without any income coming into the business at that moment, how are you able to pay off business debt until your business starts to make money? Would you have to use some form of personal funds? Yeah, I mean, if you're racking up business debt, but your business isn't making any money, then you're gonna have to figure out some way to pay that debt. It depends on the debt, of course. If you've got a business credit card, those payments I assume are gonna need to be made right away. So if your business isn't generating money, then yeah, you'll have to contribute some of your own personal funds to the business so it can pay off those debts. If you're taking other kinds of debts, maybe a line of credit or a loan where the payment won't be due for a year or something, then that's a different situation where you don't maybe necessarily need the income coming in right now. But yeah, I mean, if you're taking on debt and the debt has to be paid, then if the business isn't making enough money, then you're going to have to use your own personal funds, put those into the company, pay off the debts. I may be overthinking this in a huge way. Don't worry, you're usually not. It's a good thing to overthink sometimes. Curious, do I need to have a DBA if my YouTube channel has a different name than my LLC? Like your business is 180 Law Co. and your YouTube is All Up in Your Business. You don't have to. If it's I don't have a DBA or a trade name registration for All Up in Your Business. I do have a trademark registration for it, but that's a whole other thing. But no, for my YouTube channel, I don't have it because I'm not really conducting business under All Up in Your Business. It's the name of my channel and some of my services, kind of. It's a brand name, but I'm not doing business under that name. So if you're in a similar situation, then it wouldn't likely be necessary that you register a DBA for it. But if you're actually conducting business under that name, in addition to having it as your YouTube channel name, that might be a different situation. So if you're actually doing business, marketing, promoting your services or products under that name and it's your YouTube name, then it's a DBA or a trade name. Otherwise, it's just a channel name and you don't really need to do the DBA typically. Hello, how much does the CPA cost? That is a great question for a CPA. They're all different. Who knows? A couple $100 up to a few thousand, depending on what you need. If you're just looking for tax preparation, maybe a few hundred, depending on how complex your taxes are. Could be a lot more if it's a lot complicated. Monthly bookkeeping or monthly services, maybe a few hundred a month. I don't know, it depends. You should ask some CPAs. Question on the date of first use. Planning on trademarking a unique name for a YouTube channel. More YouTube channel names, you guys. Lots of YouTubers on here. I'm loving it. Loving it. Okay, planning on trademarking a unique name for a YouTube channel. Got caught in a chicken and the egg scenario. Does the date of first use occur when you form the channel, or not until it becomes monetized? So neither. The date of first use isn't necessarily when you form, but it's not necessarily when you become monetized. You don't have to be making money for it to be considered use in commerce. That in itself isn't a condition. That can be part maybe of the factors if we're questioning, was this really use? But as far as a YouTube channel goes, I mean, maybe I didn't research this. There might be some very clear answer. This question may have been answered specifically. I don't believe it has been, but I didn't research this specifically. But I think, the best way to think of it would be probably the day your first video is posted. It also, though, depends on the goods and services that you're putting on the trademark application. I'm assuming the service is something related to, educational videos, entertainment content, a continuing program. If the goods and services are the YouTube channel or your videos, then your use in commerce, the date of first use, I think the safe bet would be the date that you posted your first video, assuming you were using the trademark on that date. But no, just forming the channel in itself most likely isn't going to be considered first use, but you don't necessarily have to wait until you're being monetized. But if the goods and services have nothing to do with the videos, if you're doing a YouTube channel for maybe marketing, advertising purposes for your business that sells some other goods and services, and those are the goods and services on the application, then your YouTube channel has nothing to do with it. Got it? Good information. Thanks for sharing. Thank you, and you're welcome. Question: what if I have a strong name trademark, but it's being used? If I put a word in front of it like my, would that be okay? We are geared towards helping people with a specific service, but mine is totally different. So this is a great question. Of course, you guys, the answer, again, is it depends. There's never a yes or no answer really with trademarks. The ultimate question, well, let me back up. The overall question with trademarks, when we're comparing one trademark with another, is likelihood of confusion. When consumers encounter these trademarks in the marketplace, out in real life, will they be likely to confuse the source of these goods and services or think that they might be related or something? That's the standard that we kind of work off of. And likelihood of confusion is based off of the similarities of the trademarks themselves, the similarities of the goods and services, but also with the mark itself, it depends on the overall connotation and commercial impression, like the meaning. What meaning does this trademark get across to people? And so that's probably the big part where adding my to a similar trademark might make a difference. By adding my to whatever this trademark is, does that now create a completely different meaning or completely different commercial impression of what this trademark is? If it does, then that will help to avoid any potential issues, likelihood of confusion, refusals. If it doesn't, if it's identical except for the word my, and we can't demonstrate that my really changes the overall connotation or commercial impression, then it's probably not going to be different enough. But again, also, it still depends on the goods and services. If they're in completely different classes and completely unrelated, so that natural zone of expansion thing that I mentioned earlier, if there's very little chance that either would naturally expand into each other's zones, then that's going to help in further differentiating the two. But if they're somewhat similar, or if they're in the same class, then it's really going to come down more to how does the overall meaning, commercial impression of the trademark change when you put that my in front of it. If I have a registered DBA through the county level and someone is using a similar name to mine, not registered with the USPTO, would it be logical to file a trademark now for the DBA or wait till I file an LLC in a year and a half? I mean, if you are concerned about protecting your trademark rights or your ownership of the name, then yeah, it's logical to form or file the trademark application as soon as you possibly can. You don't have to have an LLC formed to apply or register a trademark. If you've started the business now as a sole proprietor under a DBA and you get the trademark registration and then later form an LLC, you can always assign the trademark registration to the LLC at that time. But yeah, I mean, it's almost always better if protecting the name or the trademark or the brand is important to you, then yeah, the sooner the better. Don't wait. Is a blog considered a business, and should I get an LLC for it in the beginning or later on along the line? It's absolutely considered a business. Is it, if you're not making money, it might be more of a hobby, I guess, but if you are doing some income generating activities on your blog, like advertising or affiliate marketing, something like that, then absolutely it's a business, just the same as any other business. Should you form an LLC? That part's up to you. It's certainly not necessary. I guess the risks associated with a blog, it's going to depend on the nature of the blog. If you are giving health advice or health information, medical information, legal or tax information, your risk of liability might be a bit higher than if you're doing, say, a fashion blog. Of course, there are marketing. If you're doing affiliate marketing, there are advertising liability issues that could come up. So your risk exposure is going to depend on exactly what your blog is. Generally speaking, though, you're less likely to get sued for writing a blog than you are if you're a construction person building a house. That's much more higher risk of lawsuits. So if you have a low risk tolerance and you absolutely are scared of being sued personally, if you own your home, if you have a lot of personal assets that you want to protect, then an LLC is a good idea. If that's not a big concern to you, then you can start your blog as a sole proprietorship, maybe revisit the LLC thing later on. So this is on, I did a video discussing the difference between attorney-client confidentiality and attorney-client privilege, or confidentiality versus attorney-client privilege or whatever. And I explained that, in either situation, when clients tell us lawyers something, there are exceptions, but it's 100% confidential. All of that stuff. So this question is, what if you're 100% guilty and you're talking to your defense lawyer? Should you be 100% truthful? Yes, 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 yes. Always, always, please be 100% truthful to your lawyer. We can only do our jobs if we are aware of the actual facts of what's going on. If you tell us you're 100% guilty, there are very few exceptions where we are permitted to disclose that to somebody. It's rare, it happens, but we're permitted to. Most often, we're not required to disclose that. I mean, if I don't do criminal defense, but if I was representing you and you told me, yes, I killed this person that I'm being charged for murder with, I don't have to tell the judge or the prosecutor, I don't have to tell them you admitted that to me. Nothing like that. It is confidential and privileged communications that can't go anywhere, and it can only benefit you for your lawyer to have 100% truthful and accurate information. And this applies across the board, not just criminal. When you're working with a business lawyer, trademarks, I have to get information, about dates of first use. And if a client lies to me about their date of first use and I put that false information on the application, if I find out about it later, that's a situation where I think I'd have to double check it, but I'm pretty sure I have to tell the USPTO if I'm aware that I gave false information to the government or to a court. I have to tell them. So if you lie to us and then we lie to the court or something, that's going to be so much worse than if you had told us the truth in the first place. Why do people use their LLC as the registered applicant for the trademark? How's it different if I were to use my name? Because the LLC is the one that owns and will be using the trademark. It's different. It's as if I applied for a trademark and put your name instead of mine. You and your LLC are two different legal beings. It's for all intents and purposes, it's like you're putting a different person's name on the application. And so it's the LLC that's using this trademark, presumably. If you are, as an individual, as a sole proprietor, are going to be the one using the trademark, then yeah, you would be the applicant and owner. But if it's your business using the trademark, then the business is the one applying and owning the trademark. That's why it's different. Do we do trademark registration in our home state and with the federal entity? So do you do a state trademark registration and a federal trademark registration? It's not necessary typically. If you are doing a federal trademark registration, that overrides the state level registration. So if you have a federal registration, or if you have one pending, most often there's no point in doing a state level registration. Sometimes though, if we are maybe not sure that the federal registration will go through, or if our mark isn't eligible for registration at the federal level. So let's say we're selling cannabis products. Currently, anything with, there's some certain limit, but marijuana, cannabis, anything with THC in it, we can't register trademarks with connection to those products because federally they are unlawful, and we can't register trademarks for illegal products. So since I can't register my marijuana trademark federally, the next best thing is to register at the state level if your state has legalized marijuana. So if I were in Colorado running a dispensary, I would register my trademark with the Colorado Secretary of State, since I can't do it federally. So there are some situations where we might do a state registration kind of in the meantime, or if we're not sure about the federal. But if we're going after the federal registration, then usually the state level won't do us any good. I have a question in regards to specific timing of the creation of the LLC. Is there any benefit to creating your LLC during a certain time of year for tax purposes or any other reason? Or is it just the simple creating the business when you feel the passion or want to create one? Yeah, I'm not aware of any particular benefit of doing it at some certain time of year. I say whenever you're ready, you've got the funds, the resources, and the gusto to do so, go ahead and form it. I guess perhaps if you are in a certain tax bracket and you're trying to, increase your expenses so you can lower your taxable income, then there might be some benefit of forming the LLC, before the end of the tax year, so you can take deductions for those startup expenses in that year versus the next one. That's really the only benefit I can think of, is if you needed those deductions for those startup expenses for maybe, this year versus the next year or something like that. Other than that, there's no difference. Do it whenever you feel like it. If you start an LLC in one state, get a trademark for that LLC name, and then move the LLC to a new state, does the trademark stay with it? Can it move? It does and it doesn't. It does and it doesn't. Basically, it doesn't. No, because your trademark registration was for the LLC formed in one state, and now the LLC is registered in a different state. It's usually not that big of a deal, though. You can just do an assignment from the first LLC to the second LLC and record that with the USPTO. Not a big deal. All right, my friends. That is all for this episode. If you learned a thing or two, go ahead and give me a thumbs up, and you can subscribe and click the bell and share this video with all of your friends and family. And of course, check the description for additional information and resources, new business checklists that you can download for free, and some other videos, other stuff that you guys can learn some stuff from. Thanks for joining me for this episode. Thank you all so much for watching. I'm Aiden Durham, and I will see you next time.